particular significance to today's forum, focusing on judicial recusal or disqualification, was the response of 90% of those surveyed who said that judges should be removed from a case if it involves an individual or group that contributed to the judge's election campaign.
Ladies and gentlemen, to begin our program, it's my pleasure to introduce, and I ask you to please join me in a warm welcome for the chairman of our Public Affairs Judiciary Subcommittee, Mr. Richard Yant.
Thank you, David. He's basically said everything I was going to say, but my name is R.D. Yant. I'm actually a business transactions lawyer in the Chicago law firm of Krasno Saunders and chair of the Judiciary Subcommittee of the Public Affairs Committee of the Union League Club. And on behalf of the subcommittee and the committee and the club, I'd like to welcome you. Among the club's purposes in its articles of association are to resist and oppose corruption and to promote economy of office and to secure honesty and efficiency in the administration of national, state, and municipal affairs. The club has established the Public Affairs Committee with the duty to promote the objects of the club as stated in the articles, to arrange for the discussion of questions of public interest, and endeavor to contribute to the solution to those questions, particularly by educational means. Consistent with those objectives, we are happy to join as a sponsor in this event, and we are anxious to hear today's panel discuss the topic which should be of vital concern to all of us. And by the way, if anyone is interested in joining the club, there are plenty of members here, including myself or Dave Cohn. Please approach any of us and we can discuss membership. Next, I'd like to turn the program over to Bert Brandenburg, Executive Director of the Justice at Stake Campaign. Bert?
Thank you, Richard, and good afternoon, everybody. And thank you to the Union League Club of Chicago, to their Public Affairs Subcommittee, their Judiciary Subcommittee, and thank you also to our event sponsors, Chicago Appleseed, Chicago Council of Lawyers, Illinois Campaign for Political Reform, the ABA Standing Committee on Judicial Independence, and the American Constitution Society. A lot of groups care about these issues, and in a few minutes you're going to see why. Let me also thank personally some of the organizers of the event, Malcolm Rich, Brian Gladstein, Whitney Woodward, Cindy Canary, for their hard work in bringing all this together. Let me congratulate as well the organizers on this topic. We have put together what I think is an excellent program. We have drawn together an all-star team today, and our panelists are going to explain to you what's been happening in judicial elections nationally and why recusal has become a headline issue. We're going to talk about what's been happening here in Illinois and why the issue is so important in this state. We're going to hear a case study of how recusal reform was passed in another state, and we're going to hear about how the bar can be a leadership force. We're going to hear from the panelists, we're going to ask them to mix it up with each other, and we're going to hear from the audience with their questions and their comments as well. And I'll just sort of say that there are a lot of excellent materials sort of standing behind the presentations you're going to hear, and some of them are either out on the table or referred to at the table. Before we begin, however, we're going to hear a special welcome from Chicago's own Laurel Bellows, who is President-elect of the American Bar Association. She will take office as president later this summer. For those of you who don't know her, Laurel is an experienced business attorney. She's a principal at the Bellows Law Group, just a couple blocks from here. She was chair of the ABA House of Delegates for 2 years. She headed the ABA Commission on Women in the Profession. She's been president of the National Conference of Bar Presidents. She is routinely listed in the list in everybody's list of top legal power players. She was listed among Working Mothers magazine's 25 most influential working mothers in the country. Here in Illinois, she has been involved with the U.S. Senate Judicial Nominations Commission. She's worked with the Supreme Court Commission on the Administration of Justice. She has also chaired the Chicago Network, which is an organization of professional women. She was also the second woman ever to be president of the Chicago Bar Association, where she then founded the Women's Alliance. I think you get the picture. Wherever Laurel goes, look for a lot of broken glass on the floor around her. And let me just say that the American Bar Association has a busy and productive year ahead of it. So, Laurel Bellows.
do well behind this podium. Can you hear me? All of you now, can you kind of see me out from here? I had to give Dawn a kiss because she is, a role model to me and to most people, men and women, on how to fight the fight and fight it well and then get up and continue fighting, all right? And this is one of those examples where, thank you for your generous words, but thank you for taking the lead on these very, very important issues, along with the coalition of folks who are here today. So I just want to tell you how proud I am to be Chicagoan, and I'll be even more proud to be from Illinois when Illinois decides to change its model rules of judicial conduct to include some of the recommendations that you're going to hear today. So justice at stake for the last 12 years has been in the lead of making certain that our judges are not only fair and impartial, but that the country knows about it, and that's the real issue today. The issue is recusal and disqualification so that our justice is not only fair and impartial and our judges are not only fair and impartial, but that the citizens of this country recognize them to be fair and impartial. When a judge makes a decision that keeps he or she on the bench, all right, presiding over a case in which he or she has an interest or could well be perceived as having an interest, justice does not appear to be impartial. And that's the foundation of our democracy. Our courts are the place where democracy starts and hopefully never finishes, and our courts are the safe haven for every individual in our country. And there are lots of threats to our court system that we know about right now. One of them that you will hear more and more about is the underfunding of our judicial system in this state and others. There is no state in our country, by the way, that funds their judicial system with more than 4% of the state court budget. Let me say that again, that in the state of Illinois, we are funding our judicial system at only about 2.25% of our state budget. That means in a world where we believe that the judicial branch is an equal branch of government with our legislature and our executive branch, in fact, we're not. We're being starved to death. And if you're a believer in justice and you hear some specific conversation about the kinds of issues we're facing, that one is going to require an enormous grassroots effort when we're talking about funding our justice system so that we even have one. But when we have one, as we do today at least, we want to make sure that the appearance is of judges who are fair and impartial. And recusal and disqualification is one of the most important issues I could pick to take up. So, Bert, thank you for giving me a chance to say hi. Peter Bennett, I'll call out to you, who is the chair of the American Bar Association's Independence of the Judiciary Committee, and we'll be working on these issues. And to everybody else on the panel, I'm delighted to have met you for the first time and look forward to working with you on this important issue. Thank you very much.
Laurel, thank you so much for coming here. I know you have a very busy schedule, and thank you for the work you've been doing and the work you're going to be doing over the next year as president of the ABA. It's now my very great pleasure to introduce Judge Jonathan Lippman. Judge Lippman is the Chief Judge of the State of New York, and he's going to begin our program by explaining why recusal is such an important issue. And I think the best way to characterize his career is to say that Judge Lippman has been a rising star in 4 different decades. When you look at his background, it seems like every time a governor from either party finds out what he's doing, they promote him. He started out as an entry-level court attorney. He worked as a law clerk. After just a few years, he was named Deputy Chief Administrator to manage the court system for the entire state. He served 2 terms as judge of the New York Court of Claims. He was the presiding justice of the Appellate Division of the Supreme Court First Department, and I'm about 90% sure I know what that means. I'm very impressed by it. He served as the chief administrative judge of all the New York State courts for more than a decade, which is the longest term in New York history. He has served on the board of the National Center for State Courts as president of the Conference of State Court Administrators. He received the William Rehnquist Award for Judicial Excellence, which singles out one state judge from across the entire United States. That would have been enough for most legal careers, but Judge Lippman was just getting warmed up. He was appointed Chief Judge of the State of New York in 2009, and since that day, in addition to his caseload, he's been a very, very busy reformer and educator. And if I was forced to do a one-word introduction I would instead demand 2 or 3 words, and those words would be leadership, street smarts, and whirlwind. And the sponsors of this session are greatly, greatly honored that he took time from his very busy schedule to come all the way from New York to come here and talk to you. And I would just say, listen carefully to what this judge says, and don't be surprised if the rest of America hears more from him in the future. Judge Lippman.
Good afternoon. It really is a delight to be here in Chicago at the historic Union League Club, which for more than a century has played a vital role in promoting governmental and urban reform in this great city. I've been asked to reflect today on why we are all here. I submit that one of the main reasons is because we believe that the American judicial system, even with its many flaws, justifiably remains the envy of the world, that it still represents, to so many of us, a supreme achievement in the history of human affairs. Whether you're a person of limited means or you are listed on the Fortune 500, Americans today overwhelmingly have good cause to believe that the courts can be counted on to deliver fair and even-handed justice. But the other reason we're here today is that the cornerstone principle of judicial impartiality is under enormous pressure from the onslaught of money that more and more is defining modern politics in America. As you will hear today, our judicial system is being politicized and damaged by skyrocketing judicial campaign spending, with much of that money coming from lawyers who practice in front of the very judges they contribute to, and from corporations, unions, trade associations, and special interests of all kinds who are spending vast sums of money to ensure the election of judges likely to rule in their favor. Much of that money, tens of millions of dollars annually, is directed at buying television and other media advertising in support of or against particular candidates, fueling the high level of acrimony and invective that has come to characterize too many judicial elections. The role of judges in our constitutional system of government is not to reflect the will of the majority or the will of their financial supporters, but to interpret and apply the law faithfully and impartially, without fear or favor, for both rich and poor alike. But the increasing role of money in judicial campaigns around the country is causing the public to lose faith in the courts as impartial adjudicators of society's disputes and to view judges as just another breed of politician. I know that these concerns resonate here in Illinois, which experienced in 2004 the costliest judicial election on record, $9.4 million. In 2010, a Supreme Court retention election where more money was raised than all judges facing retention votes nationally raised over the preceding decade. And this year's Democratic primary election for Supreme Court, where $1.8 million was raised collectively, 2/3 of that by the prevailing candidate. And of course, Illinois was the venue for the very high-profile, really eye-opening recusal decision in Avery versus State Farm. In New York, we certainly have our own problems. We are fortunate that the judges of our high court are appointed by the governor from a merit-based judicial nominating commission list of names. So we have not experienced the kind of multi-million-dollar campaign spending seen in Illinois and other states. Nevertheless, our trial court races, which are partisan elected races, often cost between $500,000 to $1 million, particularly in heavily contested elections and primaries. And in our surrogates courts, where most of the money comes from the same lawyers and law firms who regularly practice in that court and benefit from lucrative fiduciary appointments. You will hear more about these and other troubling developments this afternoon, trends that have been reinforced by landmark Supreme Court decisions like Republican Party of Minnesota versus White, which in 2002 invalidated Minnesota's ethical canon prohibiting judicial candidates from announcing their views on hot-button legal and political issues like abortion and capital punishment. The idea of it, the end result of it was judges become like every other politician. And Citizens United versus FEC, which in 2009 effectively opened the door to unlimited spending in support of and against candidates for elected office, including judges. There is mounting evidence reflected in poll after poll that the public believes that campaign contributions are influencing judicial independence and impartiality. A USA Today Gallup poll conducted in February 2009 found that 89% of those surveyed believe the influence of campaign contributions on judges' rulings is a problem, with 52% characterizing it as a major problem. Of particular significance to today's forum, focusing on judicial recusal or disqualification, was the response of 90% of those surveyed who said that judges should be removed from a case if it involves an individual or group that contributed to the judge's election campaign. And polls across the country show similar results. This last finding points to what I think is the crucial question for all of us today. If judges are going to continue to be elected, how can we ensure that they carry out, and equally important, are seen to carry out their duties in an impartial fashion? This question is more urgent today than perhaps ever before because of Citizens United. Now that the Supreme Court has, in the words of dissenting Justice Stevens, unleashed the floodgates of corporate and union general treasury spending in judicial elections, we face a truly immense challenge in trying to come up with effective ways to preserve public confidence in our elected judiciary. There is at least a ray of hope coming out of the Supreme Court emanating from its 2009 decision in Caperton versus A.T. Massey Cole, which confirmed the need for judges to disqualify themselves in certain situations. In that case, the Chief Justice of the West Virginia Supreme Court got a contribution that totally dwarfed everything else he had received in the campaign, and yet he shortly thereafter ruled on a major case involving that same contributor, a coal company, and the U.S. Supreme Court said has to disqualify himself because it wasn't fair, because of due process issues. It wasn't fair, and you have to have your day in court. When you come, everybody has to have their day in court, not just the contributing party. Justice Kennedy emphasized in that case that states would be well served to adopt recusal rules more rigorous than the Constitution requires to protect the reputation of the courts. Today, the Citizens Union and Caperton decisions make clear that while the Constitution may protect the right to spend money in support of judicial campaigns, it may also require judges who receive those contributions to step aside, to recuse or disqualify themselves when their impartiality may be reasonably questioned. And the ABA has been terrific in this area, asking states to look at the disqualifying rules, following up on that by suggesting that there should be disqualification where you have contributions to support in an amount that was substantially important to the judge's most recent campaign. When Caperton was decided only 3 years ago, I think that really the response to it is really encouraging. 11 states, including my own state of New York, have already adopted rules or legislation specifically addressing the problem of financial supporters of judges appearing before those judges as lawyers or parties. While 10 of the 11 states have focused on the issue of disqualification, in New York we have taken a new approach. one that I will discuss in greater detail a little later today, by adopting a new rule ensuring that a case will not be assigned to a judge where an attorney or party in the case contributed $2,500 or more within the previous 2 years to the judge's campaign. With this new rule, we in New York feel that we're systematically addressing the problem at its source, determining as a matter of court system policy, of right and wrong, that judges will not be put in the position of having to disqualify themselves because we will avoid assigning them cases involving lawyers and parties who have contributed significant sums to the campaign. We are not naive. We know that we are swimming against the tide, that the role and influence of money is an all-powerful undertow in our nation's affairs. While possibly motivated by only the best of intentions, it is hard to believe that individual lawyers would spend many, many, many thousands of dollars supporting judicial candidates, or that business organizations and other groups would be willing to spend tens of millions of dollars annually on judicial campaigns unless they believed that they were receiving something of value in return. Leaving open to question the long-held premise that individuals and businesses can invest and plan secure in the knowledge that their disputes will be resolved by a judicial system renowned for fair, impartial decision-making. The courts are the linchpin of the American democratic system of government, upholding the rule of law, protecting individual rights, policing the exercise of governmental powers, and deciding millions of disputes each year. The public must have complete confidence that the judiciary is discharging these critical functions with the utmost integrity, fairness, and independence. If the public comes to believe otherwise, then we may as well throw out our judicial robes, because we make no mistake about it. As judges, we derive our very authority and our legitimacy from the public's trust and confidence in our ability to live up to these values. Without that belief that the judiciary has a unique role in our tripartite system of government, a neutral role, that makes us different from the political branches, the rule of law that defines us as a people is in great peril. What is at stake is the very integrity of our judicial system in the eyes of the American public. We have an obligation to work together to surmount the difficult challenges posed by today's forum, and to envision and push for a strong reform agenda that reaffirms the impartiality and independence of our courts, an agenda that reaffirms public trust in the judiciary in Illinois, New York, and around the country. Thank you very much. It's a delight to be here.
Judge Lippman, thank you for setting us in motion here. In addition to Judge Lippman, I'd like to introduce the other panelists who I'm honored to call colleagues and pleased to call friends. They come to us from three of the leading national organizations who are working on issues involving fair courts. Adam Skaggs is Senior Counsel for the Brennan Center for Justice's Democracy Program, where he works on a range of issues related to money and politics, on fair courts, and on voting rights. He was a litigator at the firm of Paul Weiss in New York. He is widely published and quoted on legal affairs. In addition to earning 3 degrees with distinction, he clerked for a federal district court judge and an appellate court judge on the federal government, I should say. He is one of the nation's foremost experts on judicial recusal and disqualification, and I would point you toward reports that he has published on the Brennan Center's website. Cindy Gray has directed the Center for Judicial Ethics at the American Judicature Society, which used to be here in Chicago and is now in Iowa, for more than 2 decades. And Cindy is a a national resource. She is a one-woman clearinghouse for information about judicial ethics and discipline. She has trained thousands of attorneys and judges. She produces the Judicial Conduct Reporter, which is an indispensable resource in this field. She is a frequent consultant on judicial conduct to commissions around the country. And my understanding is now she's bringing judicial ethics into the 21st century with haiku-like Twitters, which I'm very eager to hear more about. And Peter Bennett, who is chair of the committee that Laurel mentioned, the American Bar Association's Standing Committee on Judicial Independence, has therefore one of the most important positions in that organization. Peter himself is a Mainer with a distinguished legal career as a legal reformer. He's worked very hard, particularly within the ABA, on the issues you're going to hear about today. And he has worked, as you may hear about, I think, as well, on what have been very tricky and difficult issues for the ABA as they've tried to work to move forward on these issues. So we're going to ask Adam actually to sort of start us off by giving us a sense of the national picture and the national horizon. Take it away, Adam.
Thanks, Bert, and thanks to our hosts here and to all the organizations that have pulled together this terrific event. It's an honor and a privilege to be here to speak with you. As Bert suggested, I was asked to sort of give a little bit of a national overview of the situation with respect to judicial recusal. And I want to start by taking a quick step back to talk briefly about the Caperton case that Judge Lippman referred to. I understand that just over a year ago, about a year ago, in I believe this very room, in this building in any event, Hugh Caperton, the plaintiff in that case, was here speaking to a similar group and told his story. And I've heard Hugh tell that story before. It's an incredibly powerful one. It's an incredibly emotional one, and I won't attempt to do that. I couldn't do it justice if I tried. But I did want to highlight excuse me, a couple of the facts of that case because they're really integral to the national state of recusal policy development around the country. As Judge Lippman suggested, the case involved two coal companies, one a small company run by Mr. Caperton, the second a large company, the A.T. Massey Coal Company. You may remember the name Massey outside the recusal context from the tragic disaster that occurred a couple of years ago now at the Big Branch mine, in which dozens of miners lost their lives due to some negligent practices of the company. Well, that's the company that Caperton found itself competing against and found itself being put out of business by in a series of tortious acts by the Massey Coal Company. Well, in 2002, Caperton sued and won a $50 million verdict for Massey's conduct. As that case was winding its way through the West Virginia legal system, and Massey was pursuing appeals up through the state court system, the CEO, Don Blankenship of the Massey Coal Company, looked at the bench and thought to himself, I presume we've got a bit of a problem here. It'd be really nice if we could switch some of these votes. Well, at the same time the appeal was progressing its way up through the court system, one of the votes on the bench was up for grabs in the sense that one of the existing justices was up for re-election. So Mr. Blankenship picked out a lower court judge that he thought might be a judge that would be favorable to his cause, and he decided to invest about $3 million into electing that judge, Brent Benjamin, onto the bench. I think it's important first to note that that was more than any other spender in favor of Justice Benjamin's campaign. If you combined every other expenditure to support Justice Benjamin, Don Blankenship spent more. It's also important to note that he didn't give that $3 million to Judge Benjamin. In West Virginia, there's a $1,000 cap on how much you can actually give a candidate. So he only gave $1,000 as a contribution to the candidate. But he spent $2.99 million on his own through independent efforts. And I say that's important because when we look at rules and when states across the country try to fashion rules to address the variety of spending that takes place in judicial elections, we have to realize it's not only about donations directly to candidates. We have to create rules that also take into account the implications of these independent expenditures in favor of candidates. So sort of make a long story a little shorter, at least, throughout the course of the appeal, on 2 occasions, Caperton moved for the disqualification, asked Justice Benjamin to recuse. On both occasions, he said no. He cast the tie-breaking vote to throw out that $50 million verdict. Caperton finally went to the U.S. Supreme Court after his appeal had run its course and said, I believe this, the fact that this judge sat and presided over this case and in fact cast the tie-breaking vote violated my due process rights to a fair trial in a fair and impartial tribunal, and by a 5-4 vote, the U.S. Supreme Court agreed. The case was significant in articulating the fact that there is at least a constitutional limit beyond which appearances of bias, appearances of influence buying through campaign spending creates a problem of constitutional dimension. That said, of course, most of the spending that we see with isolated cases like Avery, like Caperton, most of the spending we see in elections raises questions, but not to that extreme. So the other reason Caperton was significant is by sending a clear signal to the state courts that it's appropriate, in fact, it's necessary, it's desirable for you to adopt rules that require disqualification of judges, even in cases that don't rise to that constitutionally extreme level, but raise legitimate questions. And I think the case is significant not only for sending that clear signal to state courts, but for creating some momentum. Now, it's true, as Judge Lippman pointed out, since then 11 states have adopted rules that require disqualification or recusal of judges based on campaign spending of some form or another. Some of the rules are better, some of the rules I think haven't been enforced very aggressively, and I'm happy to talk a little bit about them. There's one of the materials outside is sort of a cheat sheet that lists all the states, and folks interested in digging a little bit deeper, there's a link to a report we have on the Brennan Center that provides all the citations to the relevant rules and statutes and so forth. So those materials are available for people that are interested. But I just want to give a quick picture of what that national response to Caperton looks like. The good news is that 11 states have done something. The bad news is that a handful of states have gone in the opposite direction and actually done something counterproductive. Nevada had a rule that would require judges who receive $50,000 of contributions to recuse, and they voted that rule down. I'd like to think that $50,000 for most reasonable observers is enough to raise questions about impartiality, but in Nevada, evidently it wasn't. Wisconsin rejected some very, I think, promising proposals for new recusal rules, and in fact adopted 2 rules literally written word for word by 2 of the biggest spenders, special interest groups that have poured millions of dollars into Wisconsin judicial elections, and by a 4-3 vote, the Wisconsin Supreme Court rubber-stamped those rules, which say that no level of independent spending and no level of legal contributions to a judge is ever, standing alone, sufficient reason for recusal. So there have been some back steps. 11 states have done something. The vast majority of states, unfortunately, have done nothing. I want to talk a little bit about 2 states, Georgia and Tennessee, which are the most recent states to act, and also I think have adopted some of the most promising rules. Those states take a comprehensive approach. They look, in effect, at the totality of circumstances. How much money was spent, how that relates to other money, what proportion of the spending in the election that money represents, the timing of that spending in relation to pending litigation, whether this contributions were given or expenditures were made while a case was in the system. And in looking at all those systems, if that spending gives rise to reasonable questions about impartiality, recusal is required. Now, I think those are promising rules because they acknowledge in very complex election scenarios in states where multiple millions of dollars are being spent, often not as contributions, they recognize that spending can take many forms and that a rule needs to be flexible. I think in a situation like New York's, where we haven't seen that, we haven't seen multi-million-dollar races because, as Judge Lippman points out, our high court judges are not elected. And we haven't seen the same kind of independent spending that states like Illinois and others have seen. So I think in New York, an approach that sets sets a threshold for disqualification based on contributions only is appropriate, and I'm very encouraged and excited to see this new rule playing out. But I think in states with the type of spending we see in Illinois and other states may be better advised to look at a slightly different approach. I think the Tennessee and Georgia rules that have been adopted within the past year or so, a little less than a year actually, are terrific models. I'd be happy to talk about them with anyone who's interested, or maybe we can get into a discussion, but I think at this point I'll turn the microphone over.
So, thank you. Before we go to Cindy, let me ask you a question, Adam. You talked about Justice Benjamin in West Virginia and all the money that was spent on behalf of his campaign, and as you know, what Justice Benjamin said was, obviously that money was spent, but I know that I'm not affected by it, and Judge Lippman talked about how the judges in America have earned a reservoir of confidence, that indeed they are able to do the job of setting aside all kinds of issues that might affect them. This is what judges do every single day. And if you had an X-ray or truth serum for Justice Benjamin and found out that indeed he was absolutely 100% accurate, it just wasn't affecting him, wouldn't that be good enough? I mean, are there other factors at play here? Well,
absolutely there are. I mean, obviously there are practical concerns about truth serum and X-ray vision, but even sort of accepting for the sake of argument that we could do that, and I don't question that. Let me make perfectly clear: I don't question that Justice Benjamin firmly believed and in all good faith intended to make an absolutely unbiased and uninfluenced decision. I accept that. But it doesn't look good, and I think that's the point Judge Lippman was making. The public perceptions of the courts are an incredibly important factor to weigh, because of course the courts are the one branch of government that has neither the power of the sword nor the purse. The reputation and the integrity of the judiciary itself is absolutely vital to the institutional legitimacy of our courts. And whether Justice Benjamin, in his heart of hearts, believed he was totally above any influence, the people of West Virginia, and in fact the people of the country looking at what was playing out there, didn't come to the same conclusion. And Justice Kennedy in the Caperton decision acknowledged that and said, given the difficulty of seeing into judges' hearts and what their minds, their mental processes are, we need to accept that when objective considerations, when the view of a reasonable observer would question whether that judge's impartiality might be questioned, might be influenced one way or the other, when those public perceptions rise to that level, we need to protect the institution and disqualify those judges, even if the result of that is some perfectly impartial judges don't hear some cases that they might otherwise hear.
So, Judge Lippman, you were nodding a little bit, and I'm just curious, you're obviously in a job where your job is to take the heat, and if a decision's unpopular, then so be it, that's your job description, and yet how do you reflect on this other aspect of this issue, which has to do with the overall confidence of the public?
Well, to me, there's nothing more important. I think that, look, I've spoken on many occasions to Judge Benjamin, and he will tell you that he's a victim of circumstance. And he's a lovely guy, but the appearance is so horrible that for the judiciary as an institution, it is totally damaging to the fiber of what we're supposed to be all about. I mean, if we lose that neutrality, that view that people have that we are impartial, we lose everything. And the difference between this country and other countries around the world is the people have this almost absolute acceptance that what ultimately comes down in the most difficult cases that confront us is done from a neutral perspective. And I give you the example of Gore versus Bush. As much as a lot of people may have felt that, gee, it was politically tinged, and there are lots of different views on it, in this country, what the judiciary decided was accepted by everybody. And there may have been public criticism or anything else. In other countries, the judiciary doesn't have that respect and that acceptance. And this all comes from, again, this view of us as being the neutral arbiters of any dispute, no matter how important. So to me, Bert, there is nothing that could possibly be more damaging to the institution than to lose that perception of impartiality. And I'd also say that sometimes it goes more than a perception. I'm not accusing anybody of anything. We assume everybody has a good heart. But it is such, as I said in my remarks, it's inconceivable that people would give these millions and millions of dollars and say, gee, you know, I just because I'm a good citizen, I want to see that the judge gets support.
Thank you. So, Cindy Gray, in addition to being a national expert on many of these issues, you are here in Chicago, and you've been here for a while. And can you tell us, can you sort of bring this home to Illinois and tell us about the Illinois version of this situation?
Sure. It's a pleasure to be here. Last December, when I was doing one of my daily Google News searches for judicial ethics topics, I saw a story from downstate Madison County about a judge named Barbara Crowder. She's up for retention this coming November, and she is in charge of their asbestos docket down there. And she had issued an order assigning the majority of the time slots for trial slots for 2013 to 3 plaintiffs' firms down there. I actually have no idea what that means, but apparently it's very important when you're on the asbestos docket. And within 2 weeks of her order, her campaign received $30,000 from attorneys at those 3 different firms. And when I read the story, I thought, I wonder what she did that made them mad. Because it seemed to me something that blatant and that obvious would result in her reassignment from the case, that there isn't any way she could have stayed on the case. And so they must have been doing it as a ploy to get her off. And in fact, that is what happened. Her chief judge intervened, all the asbestos docket was reassigned, taken away from her and reassigned to a different judge. And she said that it was just a coincidence. Her husband, without any direction from her, he's the chair of her campaign, and he was making calls in the weeks after she issued that order and to those firms, and they came through. And you know, I'm cynical enough to think that maybe there was an implied quid pro quo or some sort of payback. I'm also experienced enough to know that it could have been just a really stupid thing for those attorneys to do, which is what at least one of the attorneys admitted. They are not the first bunch of attorneys or judge's spouse, for that matter, to get a judge in trouble. But in any event, the system appeared to work. I think the cases were taken away from her. She's not going to sit in those cases. We'll see if she gets retained in November. That's a separate issue. But it did attract the attention of some legislators who introduced a bill. It's H.R. 4098 into the Illinois legislature, and it's been assigned to the Rules Committee, so it's not made a lot of progress, I gather. But if it's passed, it would provide that the Illinois Supreme Court shall establish rules requiring that immediately upon the assignment of a matter to a judge, an attorney has to disclose any campaign contributions to the judge by the attorney and party in the law firm, and that the judge shall disqualify himself if it's over $500, if the aggregate contributions in the last 5 years is over $500, which seems like kind of a low amount to me. But the party who didn't donate can say it doesn't matter to me. They can sort of opt out of the disqualification, which is an important, let's see, what would you call it, a remedy as well, because you don't want people to be able to get out. If they don't like a particular judge, you don't want them to be able to donate just $500, and then that judge never has to sit in their case again. So we'll see how that proceeds. One of the problems with the bill is I read it. It doesn't seem to apply, though, to Supreme Court justices. It talks about assignments of a case to a judge. So that doesn't sound like what would happen to the Illinois Supreme Court justices. And, of course, that's where the problems arise. That's where the money is flowing in, and that's where there aren't peremptory challenges like we have in Illinois at the trial court level. Doesn't apply at the Supreme Court level, there aren't chief judges to reassign cases. There's not a lot of clear rules on how motions to disqualify would be handled. So in that respect, the legislation probably falls short, although there's plenty of time to amend it. As far as I know, there's been no effort in Illinois to amend the Code of Judicial Conduct to make the rules clear for judges at any level. As Adam mentioned, some states have done that. Now, I think reform to the Code of Judicial Conduct, or changes or rules, is not going to solve all the problems in judicial elections. There are lots of things that have to be done on all levels, beginning with the citizens. But it is a first step, and it's also something that the judiciary controls. It's something they're in control of. The code is adopted by the Illinois Supreme Court. So by amending the code, they can send out a signal of what they consider important for themselves and for the other judges in the state. So I think it's a very important step in the process of increasing public confidence in the judiciary. A lot of the reform that's taken place in the states, as well as taking place more on a procedural level than on not just what the rules say, but who enforces it. Adam mentioned the changes made in Tennessee. It wasn't just the rule, but they have new procedures for enforcing the rules, more immediate appeal of disqualification decisions, and the Supreme Court justices aren't the final word on their own disqualification in those cases. And in Tennessee, the impetus came from the Bar Association. One thing I've noticed when I talk to judges, they often think the rules work very well. The disqualification rules work very well, at least in their state. But it appears that, at least in Tennessee, the Tennessee Bar thought there was room for improvement, so they made a petition. So I think it's important for judges as well to maybe listen to the Bar and see. I don't think the Bar should call the shots, but it's important to know whether or not they think the rules are working. One other thing I wanted to mention about Caperton, there were dissents in Caperton. There were 4, and one of the reasons for the dissent was there was a prediction that there would be this outpouring of Caperton motions, and just it would bog the courts down horribly with all these motions and a lot of federal lawsuits on the issue. And since that's the kind of thing I keep track of, I had braced myself for that avalanche. I haven't seen it. Now, there's not a lot of keeping track of motions, disqualification motions. One of the problems in this area is judges always don't explain why they are or aren't taking themselves off a case. But I've looked. I have to give a talk in a couple weeks in Kentucky on disqualification 3 years after Caperton, so I was looking for case law I could talk to the folks down there about, and I really haven't found any case in which on an appellate level in which a judge, based on Caperton, or the decision in Caperton was applied to a trial court judge or even an appellate court judge in a particular circumstance. In the decision in Caperton, the majority emphasized that this was an extraordinary and extreme case. They use those terms a lot in discussing it. And so far at the appellate level, the appellate courts have had no problem finding that the cases being presented to them are not that extreme, they're not that extraordinary. The standard in Caperton is not overwhelming the courts. And of course, part of it is a lot of these arguments were being made before Caperton. It's just now they have a case they can cite in addition to the cases that they were citing before. Just last week, the Montana Supreme Court, for example, issued a decision in a case. There was going to be a legislative referendum on the ballot in June that would change the how the justices were elected and some other things. And the legislators argued that the justices on the case had to take themselves off the case based on Caperton. And the Montana Supreme Court did, it doesn't involve campaign contributions, but it involves questions about whether the justices had an interest in the case. And they did a very thorough analysis and decided that they could sit in the case, that it was just a potential speculation about whether or not there was really an impact on it. So the effect of Caperton Caperton has not been as awful on the courts as was predicted by the dissents. And it's not so far resulted in the widespread reform that I think many other people were hopeful for 3 years ago. But reform takes a while. AJS is almost 100 years old, so we understand that it takes a while. And it has started, and it's good to watch. For the states always like to see who moves first in these issues. So I think we have enough momentum in some of the areas it'll help build momentum more and more as we go along.
Thank you. So, Cindy, I'm curious, when you talk about the fact that there has not been a flood of motions from the attorneys themselves, setting aside how the courts are handling when they hear them after Caperton, why not? I mean, attorneys are paid to be zealous on behalf of their clients, to exploit every possible new opening in the law. That's what they're supposed to be doing. Why are they not trying harder after Caperton?
Well, I don't know. I think, as I say, many of these motions were already being filed. Motions, I mean, the most common ground for disqualification is the judge's bias. I have proof he ruled against me. And attorneys make motions like that, even though that is very clearly not a grounds for disqualification. So the idea that Caperton would produce a lot of frivolous motions was silly. They were already being filed. But most attorneys don't file frivolous motions, and they would look at Caperton and they would know that, yeah, this is a good case to cite in an extreme case, but in the day in, day out cases that I'm getting, this isn't going to help me at all. And so I think that's why the good attorneys aren't filing it. And there is also a disincentive to filing a motion to disqualify a judge. If the judge isn't disqualified, they're going to sit in your case. So lawyers are reluctant to do it, and they only do it in extreme and extraordinary cases, and Caperton may be there to help them in those instances.
So there's a fear factor.
That's possible.
So we've now heard from a couple speakers about a lot of the substance of recusal and recusal reform, and we're going to come back to some of those topics, but the next two panelists are going to talk a little bit about the process of thinking through the reform and enacting it within the legal establishment. And first, we're going to turn back to Judge Lippman, who referred briefly earlier to changes made in New York State under his watch, and ask him to talk a little bit about how they came about and what lessons came out of that experience for people here in this state.
Sure. Let me tell you the approach that we took to this whole question. First, set into context, New York has about 1,300 state-paid judges. 75% of them are elected in partisan elections. That's 75% of the trial court judges. The high court, as I indicated before, is a merit system that goes back to the 1970s. We have the usual, what I would call the usual conduct rules that say you should disqualify yourself if your impartiality might reasonably be questioned. Judges can't directly solicit funds, but they can appoint committees who do solicit funds, with the idea being that you have to raise funds to run, but we know you're not biased because you didn't raise the money, someone else did. As I indicated before, for trial courts to have almost $1 million in particular races seem astounding, but we get that in New York. My view 30 years ago, this was all fine, but in the age of laptops and when the Board of Elections contributions list is available on the website, knowing who made contributions to judges are as available as yesterday's baseball game or box scores that appear in the paper the next day. It just doesn't make any sense. In my state, judges have, the committee has a cocktail party for contributors. The judge appears at the cocktail party, but yet he doesn't know who the contributors are. I mean, it's just the appearance is horrible, and the question is what to do and how to do it. In New York, as a backdrop, certainly as the chief judge, I had gone to a lot of meetings of the chief justices of the United States, so we talked about what you can do, where you recuse, where you don't. I look at it as dancing on a head of a pin, how much and when, and The ABA has put out some terrific factors, which I'm sure you'll to consider that you'll hear about. But to me, the whole process is tortured, with judges having to look at their inner souls and are they biased or not biased? Does the contribution influence them consciously or unconsciously? And the recusal, for the most part, in most conventional systems, is up to the judge, even though some have implemented the system of appeals or another judge also taking a look at it. We've tried to get a merit-based system across the board in New York. Not going to happen. The political system is invested in the political election or partisan election of judges. Judges and lawyers resent being asked to rule on these things. Lawyers hate, they don't want to get up in court and say, gee, I did something wrong, I want to disclose, I made a contribution to the judge, and the judge doesn't want to raise his hand and say, you're right, and I did something wrong, I'm going to recuse myself. It is distasteful to them. They really are troubled by it all. Putting limits on contribution, not often politically viable, very difficult, and the system is these people have to run for office. And to run for office, it takes money. Whether one believes you shouldn't have an elective system is another issue altogether. There is, I think it was mentioned before by Cynthia, there is this fear factor. Lawyers, the last thing they want to do is go to a sitting judge and make a motion to disqualify that judge. And in our state, just as the polls that Justice Estake has done and the one I mentioned, USA Today, they all say the same things, that the public views all of this from a very cynical perspective. And as a backdrop, we obviously had what we talked today, white, capered, and Citizens United. So that's what confronted me in 2010 when I really said, after Caperton, we really have to do something, and the issue was what? I believe that money, the contribution to judges is corrosive of every thing that's vital and important to the judiciary. The appearance and the reality are terrible. As you may have gathered, I don't have much confidence in the conventional approaches. Have my reservations about motions by lawyers and judges deciding, or even by the judge next door, deciding whether the judge should recuse. This is what I was wrestling with in New York, and also, of course, whatever we did, I recognized we would alienate much of our constituency and the political people. My background, as Bert had mentioned, was I had run the court system as the chief administrative judge in the court system for more than a dozen years, and I'm used to taking the simplest route from A to B, and I just would B to A, I would guess. I don't believe in beating around the bush, and I think sometimes you just have to take the monkey on your back and take the heat and do what you think is right, and that's what I tried to do in New York. And the approach that we came up with was to cut this off at its source, to treat it as an administrative issue and say that we're going to make an assignment rule, not a recusal rule, and that the judge will not get the case if someone who's contributed $2,500 or more to that judge, or $3,500 in the aggregate. I'm going to tell the judge you're not getting the case and you're not being assigned to any case involving that lawyer for 2 years from the time that the lawyer or the individual gave the contribution. I came to the $2,500 by looking at the election public contributions and try to find a middle ground that was enough, was not trivial, and yet not was so high that it didn't have any meaning. We figured out early on you have to have a waiver system that, as Cynthia mentioned, you can't have someone make a contribution in order to get the judge off their case. So the person who didn't make the contribution can waive. We give them 20 days if they want to waive. If we don't hear anything from them, we assume there's no waiver. The normal lawyers can still make motions. I agree with Cynthia, they don't. And our ethical normal rules still apply. How to adopt it? I did not see it as a judicial conduct rule. I went to the 4 presiding justices of the state, along with myself, who constitute the administrative board, the rulemaking body, the chief administrator's rules, and I was a chief administrator at one point, but I made clear to the presiding justices that I, as the chief judge, would do this. I raised it at my State of the Judiciary address, and I did not ask around the bar, the politicians, the judges, or anybody else before I did it. Because, and I was talking about this with Adam beforehand, I believe that if you raise volatile issues. So I announced this thing at my State of the Judiciary. We sort of took everybody by shock in New York, because it was, I couldn't even figure out where this fit in because they're doing it in such an unusual way. So far, so good. Anecdotally, we know it is a deterrent. At the very least, we'll see a lot of contributions of $24.99, which tells you something. We have some preliminary data, which is rough, but we think is useful. We're really only going through one partial cycle. This year, we're going through a full cycle, and we'll have a lot more data. But of the 48 judges who ran in this partial cycle, 12 to 15 of them had cases reassigned from them. Of the 48 judges, 13, less than a third, had contributions of over $2,500. Of those contributions, of significant contributions, 22 of 171, about 13%, were over $2,500, and that's down from what we estimate was maybe over 20% before in the really heavily contested races. The process is simple. We send an extract from the Board of Elections contribution list to districts around the state in a combination of a computer program and manually adjusting it. We make sure that those judges don't get cases involving people who contributed more than $2,500. We take the entire burden. The judges, the lawyers are not involved. Again, they're still free to make motions. We put the contributions on our website. We want everyone to see what those contributions are, and if the shoe fits, wear it. And again, the unique part of it is we do it before the assignment. You don't get the case. We don't require recusals or disqualification after the case. It's simple. It's easy. There's no agonizing for the judge or the lawyers. It is what it is. We've tried to eliminate gamesmanship to the best we can. I also agree very few motions are made in our state. That's just not the way it works. Amazingly, judges, lawyers, the politicians are not complaining at all because we're just doing it. We're not, asking them to say, oh, I did something wrong, yeah, I'm going to... That's not the way it works in New York, and it's been, I wouldn't say popular, but no one complains about it. The one flaw line in our system that I see is that we don't address independent monies, and because we don't have it coming to the high court, it hasn't really been a problem in New York. I think if it becomes a problem, we treat it the same way with disclosure and then fitting it into our system. From the chief judge and my perspective, the judiciary as an institution, again, impartiality is everything. If we lose that, we have nothing. In the modern world, I don't think we can cover our eyes to what is so obviously in front of us. What could be more corrosive than to give a contribution to a judge and then come with a case in front of that judge within a relatively short period after that? To me, it cries out for leadership in the judiciary, in the bar, in those groups that are concerned with good government and an independent judiciary. And from my perspective, there's no compromise on this issue, which goes to the heart of our credibility as a judge and to the public's, as a judiciary, and to the public's trust and confidence in what we do. So that's kind of the New York story and where we are as of today.
Thank you. So, Peter, the role of the bar has now been referred to a couple of times here in terms of these issues, and the American Bar Association is the nation's, perhaps one of the world's largest professional associations, and struggles with issues like these regularly. That's part of what it does, and you've been in the middle of many of those discussions and struggles over this particular issue within the ABA, and I'd be very curious to hear your sort of views from inside that debate.
Thank you, and thank you for having me here today. Before I give my comments, let me just say something about the leadership that Judge Lippman has exercised on this issue. If every state in this country or every state judiciary in this country would do what he has done, we would have far fewer problems. And one of the challenges that the ABA has had on this issue has been getting judges willing to exercise the type of leadership that has been demonstrated by Judge Lippman in New York. What he did was extremely confidential. It may be accepted by people now that it's in place, but I can promise you, having worked through these issues within the ABA over the past 5 years, that there are plenty of people out there talking behind his back who weren't happy about what he did.
About that, I am sure.
And that's a great lesson in leadership. I'm here on behalf of the American Bar Association. We have roughly 400,000 members. We are the largest voluntary membership organization in the world. Sadly, only about a third of the lawyers in the United States are members of our association. And if anyone here is not a member and has interest in membership and in getting involved, I'd ask you to come talk to me after the program. I started volunteering for leadership things in the ABA about 20 years ago. And it's a merit-based system. People who want to get involved are given the opportunity, and I'll be happy to help anybody who's interested. One other sales pitch for the ABA, amplifying on some of what I've heard today, and that is if you've got time on Friday afternoon, August the 3rd, it might be worth your while to come on over to the Weston River North Hotel. And in one of the ballrooms, you'll find my committee holding a program called our second annual Forum on Judicial Recusal. That in and of itself isn't sufficient to probably make any of you interested in showing up, but what might interest you is that Justice Benjamin will be making his first public speaking appearance post-Caperton. And the event is no charge, although I'd appreciate it if you do come that you register for the meeting. But we've got very lucky and do have Justice Benjamin joining us. The ABA has been interested in issues of judicial ethics forever, but about 15 to 20 years ago, the ABA stepped up its efforts on the court system, protecting the judiciary, creating the standing committees on judicial independence and what's called federal judicial improvements, and started taking actions that ultimately led us into the recusal disqualification debate. We've always been interested in trying to improve the public's understanding of the role of the judiciary. It's really sad, but the public's understanding, and that really doesn't include people in this room, but it's really at a historical low. A recent study concluded and found that 36% of the respondents surveyed can't even identify all three branches of our government. Believe it or not, fewer than half the people understand that when a court issues a split decision, and in this particular study it was what's the difference between the effect of a decision issued by the United States Supreme Court where the vote is split 5-4 or 9-0. Most people don't even understand that a decision is a decision and it carries the same weight regardless of the outcome. The media has contributed greatly to the problem as well, because with the 24/7 news cycle, a lot has changed and a lot gets brought to everyone's attention. And so our association set out 14 years ago to start trying to rebuild the public's trust in the judiciary. Our committee has three major goals. One is to assist in responding to infringements of judicial independence. The second is to encourage public awareness and appreciation of judicial independence and merit selection. And merit selection, again, would take us a huge step forward in getting around these problems. And finally, to recommend ways to improve institutional independence and to encourage judicial accountability. 5 years ago, when recusal disqualification really wasn't on anybody's radar screen yet, our committee had a brainstorming session and decided that this was a growing issue. We saw the increases in campaign spending in judicial campaigns and realized that there was a problem that needed to be addressed. And so about 5 years ago, we applied for a grant so that we could study the issue of judicial recusal and disqualification and try to come up with ways to improve the system and enhance the public's confidence in the judiciary. What started that thinking were some of the early cases, Avery versus State Farm, which Judge Littman mentioned, that involved your Justice Carmeier, the Cheney duck hunting trip, when Justice Scalia refused to step aside. And these were situations where the public rightly had the ability to question whether the judge could be partial or would be partial or impartial. And intense public scrutiny was given to these situations. In 2002, we had Republican Party of Minnesota versus White, and that struck down the announce clause in Minnesota's Code of Judicial Conduct. And about 12 years ago, the ABA actually adopted an amendment to the model code, the judicial code, that did suggest that states adopt strict dollar cutoffs, but no state in the country was willing to take the bold step forward that Judge Littman finally did, and that's partly why I applaud him. But again, we were out in front of the issue, but our leadership was flagging we couldn't get much done. So we set out on this project. We conducted research. We had a reporter. We held public hearings at various places around the country that were literally open to the public, and anybody who wanted to be heard was allowed to be heard. We debated ideas, we debated proposals, we surveyed what was out there, we found what we thought were the problems, and we looked at the appropriate reforms. By way of example, one of the problems you've heard about today is what I would call the debt of gratitude. When somebody donates a lot of money to a judge's campaign, there may be a perception or a feeling that something is owed in return. One of the things that we found really hadn't been addressed was what's called the debt of hostility, which is when you give money to the judge's opponent. In the middle of our project, Caperton happened, and on June 8th, 3 years ago, the Supreme Court said there's a serious risk of actual bias when a judicial campaign contributor with a personal stake in a particular case, and apologize, I'm reading a quote, has a significant and disproportionate influence in placing the judge on the case by raising funds. Our committee filed an amicus brief in that case on behalf of the American Bar Association, and we were instrumental in urging the Supreme Court to address the due process issues inherent here. When the decision came down, our president at the time, Tommy Wells from Alabama, hailed the ruling and issued a press release talking about our recusal project and the fact that our committee would then be stepping forward in trying to sharpen the issues and advance the debate and come up with reforms for courts to consider. After Caperton, we got hit by Citizens United, and that only made our work that much more important. To some, it made it more controversial. And even before Citizens United, the issue of money in campaigns was already a serious issue. It took us approximately 3 years to come up with a set of reforms. And in the American Bar Association, when somebody wants to create policy, they write a resolution, they write an accompanying report, and then they place that resolution and report in front of the association's House of Delegates, which is a 535 plus or minus member body that's composed of representatives not just of the American Bar Association, but of virtually every state bar, actually every state bar, and many, many, many county and city bar associations in our country. And the House of Delegates debates policy recommendations and adopts policies that speak for the voice of the profession. We came up with what we thought was a really great work product, and it turned out to be one of the most controversial initiatives that I have ever seen go forward in my 20 years of bar leadership within the ABA. We ended up having to withdraw our initial work product that was presented to the House and sit down and negotiate with myriad entities, each of whom were stakeholders, each of whom had points of view that wanted to be heard. Opposition came from people we never would have thought it would come from litigators, from judges, from all quarters. And ultimately, we rewrote parts of what we did and came up with what's called Resolution 107 and its accompanying report, which you can pick up on the table outside the room. One of the great things about working in an association with so many stakeholders at the table is if you work really hard at something, you can collaborate and reach consensus. And I was proud to be able to say we found consensus. We found it not only within the ABA and the House of Delegates. We had the support of an organization called the National Center for State Courts, and we received ultimately the unanimous support of the Conference of Chief Justices of the United States. And that endorsement was a very significant endorsement. So what is it that we came up with? Number one, we want states to look at their recusal procedures and bring them into the 21st century. The world has changed, and procedures need to be updated. They need to be clear. They need to be understandable. The bright lines, we think, are better than the gray lines. But one of our significant recommendations is that when a judge refuses to disqualify or recuse him or herself, two things should happen. Number one, there should be some form of a written or recorded decision so that the parties can know the reasons why the judge felt that he or she could still be impartial. Also because it helps to create a body of law that may guide other courts going forward. But secondly, to enhance that process and to help to restore the public's appreciation of the role of the courts, these decisions should be immediately appealable and promptly reviewed by a disinterested judge, either on the same court or on a higher court. And it's not that we don't believe that judges making these decisions are making, we don't think judges are making flawed decisions. Judges show up every day, have a very difficult job to do, always end up making someone upset because they're called upon to make decisions. And it's not so much that in handling these motions, judges are making bad decisions. I think that's the extreme exception. But it's the public perception. It's the prophylactic effect of having review on how the public will view how our courts function. In addition, in those states where judges are subject to election, we want the states to really adopt strict disclosure requirements both for litigants and lawyers who provided campaign support so that judges can evaluate who did support their campaign, who did support their opponent's campaign, and use that information to make informed decisions as well. So we want states to start making that data available. Some states do, many states don't. Adding transparency to the process will only make things better. We've now embarked on what's called our implementation phase. And although 11 states have worked on this issue in some fashion, we're now attempting to find some states that will work with the American Bar Association on this issue. Not so much that we want the ABA to come in and dictate to any state, but more that we have developed a body of knowledge and expertise from the 4 years of work that we did on the grant that we think can help states tailor solutions to their own needs. There is no one-size-fits-all solution here. Some states, well, we'll take Maine, for example. What might happen in southern Maine in terms of having recusal motions reviewed is very easy because the population of our state is heavily concentrated in southern Maine. But if you go to far northern Maine, there's one judge up there who's on the Superior Court, and he's only up there part-time. And so if we have to wait for another judge to be able to come to town to hear something, justice isn't being delivered. So states have to nuance these things and work through them. But that's where we are in this process. At the same time, the Center for Professional Responsibility is working on creating amendments to the model codes that will attempt to at least provide model procedures to address some of this. There was a set of amendments proposed 5 months ago now that was the subject of a public hearing in February of this year. The hearing itself was so controversial that the committee that conducted the hearing, I sat on that panel, withdrew the proposed amendments and has gone back to the drawing board because this issue has so many permutations that none of us always see, and things just keep coming up. But in essence, we're out there trying to partner with the courts, partner with bar leaders, lend our expertise, and hopefully find that gold standard that then everybody can embrace. Thank you.
Thank you, Peter. I want to get to audience questions and comments in just a minute. I do want to, as a matter of kind of fleshing out the world of how recusal reform might work, ask a couple sort of short answer questions of some of the panelists here. And you've now heard a number of practical ideas that are out there for various forms of recusal reform. And I want to start with a quick question for Peter. You mentioned one of the things that the ABA came out with was the idea that every judge who makes a decision as to whether or not to recuse, when asked, might be subject to the litigant taking that to another judge, presumably if they declined. And when that very idea was debated in Michigan, which ultimately went on to adopt such a rule, and they're about the only state that I'm aware of at the high court level done so, or at least one of the few, it was a very contentious debate amongst the judges. And one of the arguments on the other side was, well, this will lead to judges strategically working to knock each other off cases in order to gain majorities. And I'm just curious, did that come up? What was the reply to that in the discussions you had?
It did come up in the discussions. It came up primarily after we came up with our original work product and withdrew it and started reworking the issues with the naysayers, if you will. We decided not to back down on that. We felt that the issue of restoring the public's trust was too important an issue, and that the one way to do it was through having these decisions reviewable by an independent either judge or higher court.
Gotcha. And then my understanding is, unless I'm wrong, is that in the couple of years now since Michigan did adopt the rule, I don't believe there have been any instances of judges taking each other off the cases. There have been a few motions filed, but unless I'm mistaken, I don't think it's actually happened yet in terms of floods that haven't come yet.
Yeah, not only do I think it hasn't happened, one of the things that having this type of system in place does is it puts the judge who's under the light in the position of having to make a better informed decision so that we don't necessarily get into these problems. Because if they know they're going to get knocked out, they're more likely to step aside.
Gotcha. So it sort of affects the process up front. So, Cindy, let me just ask you real quick. There's been reference made here in terms of customizing solutions to high courts and district courts. And I'd be curious to have you share your thoughts on sort of principles that in which if you're approaching recusal for appellate courts and trial courts, whether there might be differences in how you approach recusal, or perhaps not?
Well, there obviously have to be differences in the rules, the procedural rules that are applied, just because the procedures are very different and the availability of appeal is very different. I don't know that the standards, what the code says, what circumstances should result in disqualification should vary depending on the trial court level. And in other instances, they don't. It does, you know, if a judge is related to a lawyer within the third degree, doesn't matter if they're a trial court judge or they're appellate court judge, they need to take themselves off the case. But the procedures need to vary because the trial and appellate court procedures are very different.
And Adam, reference has been made a couple times to disclosure issues and transparency issues, and I'm just curious, given all the money swimming around and the fact that it comes through different sources, through direct contributions, through independent expenditures, what's the role of transparency and disclosure in recusal reform, and how important is it?
Well, in a word, it's very important. If you don't know where the money's coming from or who's spending it, it's tough to fashion effective disclosure rules. If I could take a quick moment and respond to something that you were just speaking with Peter about. Bert, I think you're right that immediately after Caperton, Michigan was the only court to adopt, the Michigan Supreme Court, I should say, was the only court to adopt rules such that the remaining justices of the court could review a written decision refusing to recuse by one of their colleagues. Since then, Tennessee has, with its new recusal rules, also adopted a similar policy. In neither state has any of the concern materialized as far as gamesmanship among the justices, and in part in reaction to the initial response to the Michigan rule or concerns about it, we did some research, and our research, which is also cited on the one-page fact sheet that's available outside the room, identified at least 8 other courts in addition to those 2, so at least 10 Supreme Courts where they have these rules in effect. And as part of our report, we interviewed judges in Mississippi and Georgia and Texas and Vermont, where some of the states that have these rules. And in every case, the justices reported to us that these were not controversial. These were not used for gamesmanship. These had not created more tensions in the court, and in fact, created a healthy culture of consultation and collaboration. So, the report that the tables we have outside is extracted from identified many of the same elements that Peter's committee has focused on. And I think that absolutely requiring transparent decision-making is important because it gives a basis to review these decisions. And I think that review by a wholly objective decision-maker is important. You don't want to burden the courts with rendering long written decisions on frivolous and patently ridiculous and untimely motions, but there are ways to draw those lines. To respond to your question about disclosure, again, it's vitally important. If we don't have transparency in the money in elections, it's difficult to enforce any of these rules. And there's a tension there between old-fashioned ethical rules that require judges not to know anything about the spending and the reality of the Internet age, which is that even if they don't want to, it's pretty hard to avoid knowing who your contributors are. So I would advocate for a fully transparent system. If we're going to elect judges, if they need to raise funds, they're going to do so, and let's bring sunlight to know who's doing that spending. And the last point I'll make is to respond to the New York rule that Judge Lippman talked about, and again, I think this underlines that there is no one-size-fits-all. That rule, which I think is terrific, and I too commend your leadership, and I'm excited to see that rule, that wouldn't have required disqualification in the Caperton case. Just to underline that point again, because all of that money was independently spent and because only $1,000 was given to the judge, he wouldn't have been disqualified in Caperton. Now, of course, in a situation where you have a state with this independent spending, that's why you need to fashion different rules, and one size doesn't fit. But in many states, including New York, we don't have adequate disclosure. And so a system that is based on assignments based on publicly disclosed information is only going to work if we have effective disclosure of all the relevant spending. In New York, for example, you could run, let's say Mr. Blankenship came and spent $2.99 million in New York. As long as he didn't say vote for Smith or defeat Jones, he wouldn't disclose any of that information. If he said call Justice Smith and tell him to start being tough on crime, he could spend $1 million on that. Nothing in the public record. That money isn't disclosed. And there are holes in disclosure all over. So while I understand the benefits of a system that doesn't require on disclosures by lawyers or judges, doesn't require sort of going on the record and saying, oh, maybe this was, you need to know about this if it raises any ethical questions, unless you can get the legislature, and we're working with the New York legislature to try and get good disclosure back in New York, but unless you can get the legislature to require disclosure of all independent spending, whether it expressly advocates for election or defeat or not, you're only going to be able to get disclosure and implement meaningful disqualification if you require disclosures by either the parties, their lawyers, or the judges, to the extent the judges have that information. And so we've advocated a rule that at the outset of litigation, just as in federal court, corporate parties have to disclose if they're entities that own more than 10% of their stock, litigants and their counsel at the outset of whatever stage of litigation file an affidavit that discloses any relevant spending above a reasonable threshold to the judge or the judge's opponent. By the courts adopting those rules, they can bring transparency and make meaningful disqualification, even without waiting for legislatures to act, because as we all know, they don't always do so in a timely fashion.
Please.
I agree totally, Adam, that disclosure is a key to this. I think that if you have the disclosure, my main consideration is I prefer a bright line rule. And it works at the trial level because we don't have much of this independent money, and therefore we know what the contributions are. We cut it off at its source. I think you could have the same kind of rule if you had disclosure of independent contributions. You do the same thing. Maybe it set the thresholds differently, but you cut it off at its source. So I think we're on the same page, and certainly a key part of whatever system you want to put into place requires disclosure, whether it be of individual contributions or independent money. Yeah.
Thank you. So we do now want to open this up for the audience, and if you have questions, we have a microphone here. We ask that you stand, that you identify yourself, and ask a question rather than make a comment here. But why don't we start? We have a hand up over there.
Okay, sir, if you just identify yourself and ask your question. Adolfo Mondragon, a private solo practitioner. So following up on this, on the disclosure discussion, how do you deal with, for example, surrogates who might be disclosed, but because you cannot discern who they are the surrogates of, or if they're a straw PAC or a PAC that doesn't have to disclose? How do you deal with that issue? So they are publicly disclosed, it's PAC X, but because it's a surrogate working for someone, you don't know how it leads from PAC X to the actual person doing the litigation or going before the court.
I think you deal with it with great difficulty because there are loopholes in everything. If you try hard enough, you can get around almost any rule. But I think the idea is to have things that make sense in place that are deterrents to that kind of thing. But I think it's very hard to eliminate every possible angle that might come to play, and you're right.
So is there maybe some kind of oath that the litigants have to sign and say, like, I, knowingly have not contributed to someone?
My own view is that it's a very difficult thing, as I said. You get these disclosures, to get up and say what they don't want to say creates all kinds of other problems. But yes, you could. I just don't think it's particularly viable, at least from my perspective, in New York.
Adam, did you want to add to that?
Adam?
Yeah, I think there's two ways to get at that problem, and their respective viability is something we can debate. The first way is to have the legislature pass a comprehensive disclosure rule that requires parties to disclose not only their own independent spending, but contributions they made to other organizations with either the knowledge or reasonable expectation that that contribution would be used by that conduit organization to, and that draft language on that was floated by the Obama administration for a disclosure rule about government contractors, and that met incredible resistance and hasn't been signed. The other way is to require counsel for the parties and on their own behalf to file disclosures of, again, any independent spending that they personally, were responsible for, or any contributions that were made to other groups with the knowledge or expectation that that money would be used. It's not a perfect system. To suggest that clever contributors or spenders aren't going to find a way around any rule is, to live in a world I'm not sure I live in. But beyond that, the resistance to these rules by the parties that are spending these vast sums of money is extreme. And these are parties that aren't just spending the money in judicial elections, they're spending it in legislative and executive races. And so if they don't want these rules to get done, let's just say they can get their calls taken by the folks that we would need to adopt these rules. So it's a huge challenge.
We have the next question over here. Ma'am, if you'd stand and state your name and your question.
Joan Steinman. I'm a professor at Chicago Kent College of Law. Judge, in New York, what happens if the contribution comes after the case assignment rather than before? Are there similar bright line rules that if a judge receives a $2,500 contribution in a case he's already hearing that he must recuse? And if I may, are there any rules for sanctions for lawyers or others if you could establish that they gave money in an attempt either to influence the judge in a particular case or to chase a judge off a case?
I would hope so. You have a whole disciplinary system, that's geared to misconduct. So I think in that case, if one could prove such a thing, which is very difficult. On your other question, the reason why it really doesn't come up particularly is, obviously, you run for office in a particular cycle. After that cycle, you're elected, and you're not running for office. There's nothing to contribute to. So we try to focus on the election cycle, but you're right that you could, because of the campaign laws or whatever, there could be a contribution that comes within the cycle, and that would cover it. But in general, you run for office, you get your contribution, you get elected, and then you're just a judge sitting, and there's no one making contributions the next time you come up. But yes, you're right to focus on the cycle, and again, I think it goes to the point we're all making. There are ways to get around things, like if the judge has a debt and maybe it's still within the period and it's after the election, but within the cycle, that situation, can happen. Thank you.
Other questions? Okay. Sir, if you could stand and state your name and your question, please.
Thank you. My name is Julian Frazen. I'm a retired circuit court judge from Illinois. It's been a while. Where's this guy who brings $3 million to your campaign? No, I'll tell you the truth. Back in the old days, we didn't get that kind of money. There was no way we got it. And what bothers me with what you're saying here, you are really imagining and assuming the worst of judges. I mean, I didn't even know where the money was coming from. They said, you can't look at that list, you can't look at that list. But somehow you kind of find out, he only gave me that. And the thing was that it was my own conscience that governed what I would do. And I had good friends of mine that were there. I really can't. I don't want to take this case. It really makes me feel bad. Why we can't rely upon that? What you're relying upon is that the judges are the worst. The $2,500? Come on. What did the guy say? Who was it? Romney said, I wouldn't take $2,500. I'm running for office, right?
Yeah, it's a very good question. And the judges in our state and states around the country are offended. What we get is that you think for $2,500 or $5 or $5,000, we can be bought. You're absolutely disparaging us. You're creating attributing the worst motives. And my answer is that I have confidence in you without knowing you at all. If you had a long career in the judiciary, that you followed your conscience, and the last thing in the world, and that applies to Brett Benjamin too. And again, I met him, he's a lovely guy. My point to you is the damage to our institution is so great when there's a perception that Joe Schmo gave you $2,500, the next day walked into your courtroom and you ruled on Joe Schmo's case. The guy who's appearing opposite Joe Schmo says, there's something wrong here. How could it be? And the person sitting in the audience, you know, is...
Did your studies show that?
Oh, yes, that the public, absolutely.
Even the public thought.
Lawyers, yeah.
When they gave a contribution, and then later they had a case that they kind of leaned toward the person.
That is what every poll shows dramatically. So my point to you, right, and I mea culpa to our judges and say, look, you know, I think you're such a person of great character, but our institution is going to be destroyed if the public, you know, doesn't have confidence in what we do, and that's the two sides of it.
Next question here.
I'm Bob Carton. I am a sole practitioner in Chicago and an old friend of Judge Frazen's here, and I never contributed to his campaign.
But Bob,
now I tell you that.
Bob, before you ask your question, how would you feel if the judge or some other judge got a big contribution immediately before you had a case, you're on the other side, and you walk in and you know that it's a matter of public information? What would that say to you?
If it were Judge Frazen, it wouldn't bother me a bit.
Good answer.
It wouldn't bother me a bit. If it were not Judge Frazen, if it were one of the many judges whom I don't know or didn't know, I would suspect.
Right.
But as you're discussing here, trial judges and middle-level appellate courts, and you're talking about public perception, and you commented that 15% of the public knows that there's 3 branches of government, the rest don't. They don't know that there's an independent judiciary. We've had the last 10 years or 15 years of politicians doing nothing but blasting courts, particularly the Supreme Court, for making political decisions.
Yes.
Accusing justices of the most rank motives, of lacking integrity. We've watched justices get tremendous publicity because they have not recused themselves from cases that cry out for recusal. Why are we hearing so much attention being paid to the lower level courts that don't get that kind of press nationally? And I don't hear anything about the Supreme Court and the politicians that are publicizing this nationally, which does color the public perception.
I can give you my answer is that look at the last campaign that we've gone through for the President of the United States in the last period, and look at the things that they're saying about the judiciary and saying about the Supreme Court of the United States, and the other extreme is, you know, where they say that, look, this is a great idea, we're going to look at the decisions, and if we don't like them, we're going to get rid of them. That's a really good idea. Why don't we all think of that? So I'm saying, of course you're right, that it goes up and down the line, and I think Peter had mentioned, or someone did, that, you know, with the Cheney thing and Scalia. So the Supreme Court has gotten it too, you know, as to, you know, they should be recusing. And Chief Justice Roberts has said, well, they all know what, you know, they should be doing, and they're the last word. So I think all the things that we've all said apply from the lowest trial court to the Supreme Court of the United States. I don't think there's that much difference.
And I'll just add, moderator's prerogative here, for Mr. Cardin's, the other part of Mr. Cardin's question about the lower courts and the attention paid or not paid to them. I think, and our organization, along with some others, collects a lot of the data on what's going on at the high court level. And the fact of the matter is, because that's where the data is most easily collected, there are far fewer higher courts than lower courts by definition. It's what we know more about, and it's a very big unanswered question as to whether there's a similar crisis of confidence and whether it be perception or reality going on at the lower courts. You hear things anecdotally, and the better news is that there's some more data research that some organizations and scholars are trying to attempt, but one of the aspects of recusal and disclosure around the country that we've not had a chance to get into today is that record keeping around disclosure motions, and as well as record keeping sometimes around the money, is often so insufficient that if you set out today to get the answer, it'd often be very hard to do. And I know this is one of the recommendations that the ABA and others have come forward with, that actually record keeping around disclosure be
Bert,
improved.
could I just add, in New York, all the attention has been on the lower courts because of the political system, which is dominated by the party leaders as to who gets the nominations, and the fact that, as I mentioned, in the 1970s, we did the right thing in terms of the High Court, eliminated so many of the issues that we've talked about today. So all the attention in New York has been about this politically dominated system and how people become judges and the influence of campaign contribution. And that's why, at least from my perspective, we attack that as being the point of first resistance that has to be addressed.
Next question over here. Sir, state your name and your question.
Yes, it's Jim Rowicki. I'm a solo practitioner in Chicago, and this is probably less of a question, and with all due respect to the retired judge in that, and maybe I'm just overly cynical, but when I first started practicing law, we had the Judge Holzer scandal, where he was shaking down trial lawyers to buy insurance from his wife. And then we have the Greylord scandal here in Chicago. That was only a handful of years ago. And the problem is you have one or two bad judges, and they make a bad record for all the other judges. In my practice, 99.99% of the judges I have entire faith in. And I never really saw any kind of misconduct by the judge. But at the same time, it happens. And people get really disgusted with that. I, as a voter, get disgusted with that. And as to the $2,500 limit, you got to draw a line somewhere. But you go into rural Illinois, you go to Ottawa, Illinois, LaSalle, Illinois, where I'm from, $2,500 can buy you a lot of radio times, a lot of placards, and a lot of bumper stickers. I don't think that number is in any way low.
I think we have time for maybe one more question.
Okay. Other questions from the floor? We have one over here. From our chairman, Mr. Yant.
R.D. Yant. You talked about merit selection getting rid of the problem. We've had a couple of discussions here about merit selection, merit retention. We had a forum here a year ago, and what surprised me, and in Chicago, much like I think New York, the judicial nomination is the party endorsement is very important, and the primary is the race. But what surprised me when we had the forum on merit retention was that some of the minority people that were in the discussion said, you know, we've just figured out the rules, we're just getting ahead, and you want to change the rules. I wonder if anybody would like to comment on that factor.
I would just say that's been an issue in New York, the same exact issue. And I've been a judge who's been both an appointed judge and an elected judge. And I think that our judges resent when you call the appointive system a merit system, because the appointive system is only as good as the appointing authority, and sometimes it's politics by another name. So I don't think there's any monopoly on good judges that come out of either system. My own view is the system has to be meaningful and transparent, and it is harder. And again, I've been elected and I've been appointed. It is harder in an elective system to make it meaningful, because it's hard for the public to understand what makes a good judge, what doesn't, what's the basis upon which they make their vote. But again, look, we have in New York our most famous judge, Benjamin Nathan Cardozo, was an elected judge that came out of the political system. But I think the elective system just has more vulnerabilities to it, but we see plenty of appointing systems, certainly that we've had in New York, depending on the governor or the mayor, that I take an elected judge anytime, and vice versa. So I think ideally an appointed system is by nature would be better designed to get a qualified person, but in practice, I think it's difficult to say that overwhelmingly one produces better judges than the other.
I come from a slightly different perspective, having been neither elected nor appointed as a judge. But yet I think I come to the same conclusion, which is to suggest that, look, I think there are a lot of benefits that a merit selection commission with gubernatorial appointment or mayoral at the local level perhaps can bring. But I think to suggest that that's a panacea, it's a silver bullet to solve all the problems of judicial selection is just isn't true. First, politics intrudes in all the old-fashioned ways in both selection of commission members, it can at least, as well as the appointments that are then made by the appointing authority. And if the traditional model of a merit selection system, which in virtually everywhere it's implemented around the country now, includes retention elections as a component of that, well, you just have to look back, I guess, 2 years now to the most recent retention election here with Justice Kilbride, or even more so in Iowa, to see that retention elections, however well designed to remove politics and money from judicial selection or retention, it doesn't always work as designed either. So, I think if it were feasible to move from cash-drenched contested elections to a merit system, I would think that would be a good direction to go. But to suggest that they'll solve all the problems of politics and money influencing the judiciary, I think is naive.
So before we wrap up here, let me just say that I think that, oh, I'm sorry. If you had a quick final one, why don't we do that real fast?
I can usually be heard on the microphone. Would anyone like to comment on public financing, and particularly North Carolina's experience with public financing of the Supreme and appellate races? Is that, nothing is a panacea, not even merit selection, although it's the closest one we have to a panacea. But for those states that continue to elect, what about public financing?
Adam, why don't you?
Well, look, I think public financing is a terrific reform. I think it's absolutely vital. I think it would do a tremendous amount to reduce some of the issues that you see here in Illinois and elsewhere. North Carolina's system has been tremendously successful. It's been embraced by incumbents and challengers, Democrats and Republicans, and it's been wildly successful, and it's gotten those judges out of the business of working the phones, dialing for dollars, and gotten them into explaining to voters what it is they do and what their values are. I mean, if you're going to elect judges, having them talk to voters, I think, is a good thing. There was a setback last week on Friday when a federal court in North Carolina struck down a piece of that law. There's a provision of that law that gives candidates supplemental matching funds, and a similar provision in an Arizona non-judicial public financing program was struck down by the Supreme Court recently, I guess about a year ago in June. And so unfortunately, because of the political changes in the leadership in North Carolina right now, tinkering with the law is something that the legislature is not really looking at. So we tried to work with North Carolina to defend that law. There wasn't much of a political appetite given the Supreme Court precedent. We thought they could distinguish a judicial election system from a non-judicial, but they didn't choose to make that fight. So right now the system, though it's been the most successful across the country, needs some tinkering, and there's not really the political will to do that at this very moment. But that said, states can look at the design that North Carolina used. I know Illinois has looked at that here. I would encourage everybody to work with legislative leaders to get that passed, because if we're going to elect judges, if there's going to be money, again, it's not a silver bullet, but it's a huge step in the right direction.
So those of you who may have come here only for some CLE credit, may realize now that you have stumbled upon a major rule of law issue and a major democracy issue. We're really glad you came. If you are here for CLE, in addition, there are, I think, the right forms and the right stuff here you need for that. But let's extend the invitation to continue the conversation. For those of you who care about these issues, and we hope every attorney does, there are, as mentioned, national organizations you can be involved with, the American Bar Association, the American Judicature Society. You can support the Brennan Center. Our organization, Justice at Stake, does that. Here in Illinois, you can continue the conversation and support reforms by contacting the Illinois Campaign for Political Reform, by contacting Chicago Appleseed. And we really urge you to be not only thinkers, but as attorneys, we're all stewards of the law here, and we hope everybody can be a doer as well. And so with that, please join me in thanking a terrific panel. Thank you.